Hi everyone. So I'm a bit late bringing this because I've had quite a few things going on. But we're going to do a little read through of Lively's response, her reply to Wayfarer's opposition to her motion for Section 47.1 damages, the treble damages, attorney's fees, costs, etc., and punitive damages. So, the Wayfarer parties brought a meritless defamation action in New York under California law, using California-based attorneys representing a California company based in large part on a complaint Ms. Lively filed with the California Civil Rights Department. The court dismissed the Wayfarer parties' lawsuit against Ms. Lively, including their defamation claim and every other claim they alleged. They now seek to repudiate the invocation of California law to avoid the consequences of their failed litigation strategy. They advance 3 arguments for why the court cannot or should not rule on Ms. Lively's motion, all of which fail. Let's make that a bit bigger. First, the Wayfarer parties suggest that this court cannot rule on Ms. Lively's motion because it presents issues of first impression under Section 47.1, including ill-defined constitutional concerns and conflicts. It goes without saying that this court has the authority to rule on matters of first impression, including Ms. Lively's motion, especially when, as here, the Wayfarer party's own claims and litigation conduct before this court have put Section 47.1 at issue. Nor do the Wayfarer party's free speech arguments under the Noor-Pennington doctrine and California's litigation privilege change this, as the Second Court has not decided whether Noor-Pennington even extends to non-commercial litigation. And the canons of statutory construction compel the conclusion that Section 47.1 carves out an exception to California's statutory litigation privilege. Second, the Wayfarer party's argument that Section 47.1 does not apply extraterritorially where Ms. Lively is not a California resident and the film was shot outside California is similarly meritless. None of the Wayfarer party's case law addresses application of a state's law when the party resisting application itself brought claims under that state's law. Even if they did not invite application of Section 47.1 upon themselves, which they did, there exists a sufficient nexus between California and the Wayfarer parties' retaliatory defamation action based on Ms. Lively's California CRD complaint. The only conduct relevant here to justify its application. Third, the Wayfarer parties argue that California cannot apply Section 47.1 without factual findings that Ms. Lively acted without malice and had a reasonable basis to make her complaints about harassment and retaliation. In effect, the Wayfarer parties argue that the court cannot conclude that Ms. Lively is the prevailing defendant in the defamation action, which has now been dismissed with prejudice or abandoned in its entirety. Instead, they argue Ms. Lively must endure a jury trial to prove that she already prevailed. This makes no sense and runs counter to the California legislators' express intent to provide remedies to a successful defendant at the earliest stage, typically through a motion to dismiss. In a perverse twist, the Wayfarer parties attempt to justify the exact type of protracted litigation the statute was designed to curb by arguing that Ms. Lively's affirmative claims, with which the Wayfarer party's separate lawsuit had previously been consolidated, present the same factual issues as her motion under Section 47.1 and thus must be decided together to avoid inconsistent rulings. This is wrong. Miss Lively's claims do not necessitate Miss Lively to prove that she acted without malice. The Wayfarer parties did not allege otherwise in their lawsuit and should not benefit from the fact that Miss Lively's affirmative claims remain standing. Finally, the Wayfarer parties argue that Miss Lively has not established a basis upon which the court can calculate treble damages and cannot establish her right to punitive damages absent a factual finding from a jury. Not so. Miss Lively has already requested a schedule to introduce evidence of her actual damages, which will be established by the close of expert discovery on November 14th, 2025, and which the court can then treble. Moreover, California precedent confirms that a judge may award punitive damage under California Civil Code Section 3492. Indeed, that authority should apply with greater force where, as here, the malicious, oppressive, or fraudulent conduct is the Wayfarer party's litigation conduct, which is evident on the court's own docket. The Wayfarer parties should not be permitted to avoid the consequences of their retaliatory litigation tactics any longer. The court can and should rule on Miss Lively's motion at this juncture and set an evidentiary hearing to establish Miss Lively's attorney's fees and damages. Section 47.1 does not infringe the Wayfarer party's constitutional rights. The Wayfarer party's suggestion that it is somehow improper for this court to rule on Miss Lively's motion since California courts have yet to interpret Section 47.1 is incorrect. This court is plainly empowered to interpret Section 47.1, where the Wayfarer party's own litigation conduct implicated it, and the court expressly allowed Miss Lively to renew her arguments thereunder. And as a footnote, the Wayfarer parties mischaracterized the court's prior ruling, stating that the court denied relief under Section 47.1. In fact, the court did not reach the issue and expressly allowed Miss Lively to renew these very arguments. Okay, so let's go and see what the judge actually did say about that. Lively has moved for an award of attorney's fees, treble damages, and punitive damages pursuant to California Civil Code 47.1. This is the judge's order, by the way, the June 9th order on the motion to dismiss. Lively has moved for an award of attorney's fees, treble damages, and punitive damages pursuant to California Civil Code 47.1. The next sentence, the court denies the motions without prejudice to renewal in accordance with the ruling. So actually he did deny it. Yes, he did invite her back, but it's not true to say that he didn't deny it. If the Wayfarer parties did not want to face the consequences of California law, they should not have invoked it in the first place and on multiple occasions thereafter. Okay, let's come have a look. So again, I feel like Lively saying that Wayfarer invoked California law, so therefore that that applies to her claims, is a bit of a misnomer. So this is Wayfarer's first amended complaint. And actually here on these paragraphs, Wayfarers say, this court may exercise personal jurisdiction over the Lively parties, this court being the New York court, by the way, pursuant to Section 301 of the New York Civil Practice Law and Rules, because all of the Lively parties systematically and continuously conduct and solicit business within New York and have availed themselves of the privileges of conducting business in the state of New York. They then go on to say, this court may exercise personal jurisdiction over the liability parties pursuant to Section 302 of the New York Civil Practice Law and Rules, including because, upon information and belief, all of the liability parties transact and solicit business within the state, have committed the tortious acts described in this complaint within the state, and or have committed such acts outside of the state causing injury to the wayfarer parties within the state. So, they also have a footnote, though, that I think is incredibly relevant, which says, Lively has contended that California law applies to any dispute involving the wayfarer parties or the film. Without conceding that Lively's statutory claims are properly brought and with reservation of all rights and remedies, the wayfarer parties assert their claims under the substantive laws of the state of California. So they didn't say that that California is the right jurisdiction for Lively's claims. They're saying that it was right for their claims because that's where the harm was felt. Wayfarer and the individuals themselves, apart from Steve Sarowitz, all reside and work in California. So the harm from defamatory comments was felt most by them in California. Okay. Wayfarer parties also assert that this court cannot rule on Miss Lively's motion because it presents issues of first impression, including constitutional concerns and conflicts. Specifically, they argue that Section 47.1 infringes upon their First Amendment right to bring unsuccessful claims under the Noor-Pennington Doctrine and California's litigation privilege. Both arguments fail. The Wayfarer party's Noor-Pennington challenge, bare bones as it is, fails to raise free speech concerns. A court in this district rejected a similar challenge, noting the Supreme Court's caution that the pre-standard is a doctrine of antitrust law, and that its holding is firmly grounded in the text of the Sherman Act and the context of antitrust liability. The Second Circuit has not decided whether Noor-Pennington even extends to non-commercial litigation. And even if it did, it would not extend to Section 47.1, which itself exists to protect free and First Amendment protected conduct. Further, a defamation claim is not itself a constitutional right. The elements and scope of the claim may be limited by common or statutory law, as discussed further below. Moreover, any risk that Section 47.1's treble damages provision would chill petitioning activity in the form of defamation suits is outweighed by the risk, recognized by California legislator, that retaliatory defamation suits would chill reports about sexual harassment. Finally, even if Noor-Pennington applied to Section 47.1, the Wayfarer party's case would fall under an extension of the sham exception, as a baseless abuse of judicial process based on the patent deficiencies in their now dismissed claims. As a footnote, even if Noor-Pennington bars Section 47.1 treble damages, which it does not, such a bar would not preclude the independent fee shifting remedy. Noor-Pennington does not apply to fee shifting provisions. The Wayfarer party's argument under California's litigation privilege is equally deficient. As the California Supreme Court has emphasized, the litigation privilege is not without limit. Numerous exceptions to the litigation privilege have been recognized based on irreconcilable conflicts between the privilege and other co-equal state laws, such as perjury, false report of a criminal offence, and the discipline of attorneys who engage in solicitation. These exceptions have all been guided by the settled rule of statutory construction that particular provisions will prevail over general provisions. Based on this principle, Section 47.1 clearly reflects the California legislature's intent to carve out an exception to the litigation privilege to deter retaliatory defamation actions based on reports of sexual harassment and retaliation. Indeed, like each of the exceptions discussed in Action Department, Section 47.1 is more specific than the litigation privilege and would be significantly or wholly inoperable if its enforcement were barred when in conflict with the privilege. This overlap therefore reinforces, not undermines, that Section 47.1 is an exemption to the privilege. Nor is Section 47.1 an outlier. California courts have long carved out exceptions where the privilege would otherwise shield wrongful conduct. For example, as the Wayfarer Party's own authority confirms, California recognizes an exception for malicious prosecution claims. The fact a communication may be absolutely privileged for the purposes of a defamation action does not prevent its being an element for malicious prosecution. This is because California's policy of encouraging free access to the courts that underlies the absolute privilege applicable in defamation actions is outweighed by the policy of affording redress for individual wrongs. The same reasoning applies here. The legislature enacted Section 47.1 to protect victims and to remedy the financial and psychological costs of litigation. In any event, many of the public communications on which Ms. Lively's motion relies are not privileged at all, including, for example, Sarowitz's and Friedman's out-of-court statement. For the litigation privilege to apply, a communication must bear a functional connection to the litigation, i.e., the communication must function as a necessary or useful step in the litigation process and must serve its purposes, and cannot merely advance parallel interests such as vindication in the court of public opinion. Accordingly, courts consistently hold that certain public statements like those addressed in Ms. Lively's motion fall outside the privilege. Finally, the Wayfarer Party's assertion that a jury must determine malice under Section 47.1 fails. Where the facts are undisputed, as they are here, given Ms. Lively is undeniably the prevailing defendant in the failed defamation action, the applicability of a privilege is a question of law. Well, I think there seems to be some kind of confusion. Yes, she prevailed against Wayfarer's defamation claim against her. It was dismissed for failure to plead. But Section 47.1 was not considered, and she would still need to prove that her sexual harassment claims are free of malice and made in good faith to be able to rely on Section 47.1. So the fact that she's just prevailed does not automatically qualify her to the remedies of Section 47.1. And I think they are reaching incredibly hard to say otherwise. Moreover, the Wayfarer parties identify no reason the court could not decide the issue sitting as trier of fact. The Wayfarer party's extraterritoriality argument is meritless. Next, the Wayfarer parties argue that the court should not apply Section 47.1 or Section 3294 against them because Ms. Lively is a resident of New York and the underlying conduct occurred in New York. This argument fails on multiple fronts. None of the cases cited by the Wayfarer parties address application of a state law that the party opposing the application itself invoked. And as a footnote, indeed, in opposition to Ms. Lively's motion to dismiss, the Wayfarer parties agreed that California law applies to their claims. Yes, true, their claims, not hers. Ms. Lively's loan-out agreement also contained an express California choice of law provision. But Wayfarer did cite cases where that was irrelevant. Rather, their authority involves cases in which a defendant is sued in California and argues against extraterritorial application of a California statute to out-of-state parties or for conduct that occurred outside California. Or didn't her sexual harassment occur outside of California? Here, the Wayfarer parties intentionally brought suit in New York under California law for their own benefit, and now argue that California law should not apply to them in the same litigation. I don't think that happened either. I'm pretty sure she filed in New York. Wayfarer filed in California against the New York Times only. And then at the hearing in February, they just agreed to consolidate in the same court. They didn't bring in anything to New York intentionally. She's full of shit. This position is absurd and must be rejected. Her position is absurd. The Ninth Circuit has squarely rejected the Wayfarer party's position on choice of law, holding that a California statute could apply to out-of-state parties where the parties agreed to apply California law. Now we have a footnote. Courts in this district follow the guidance of California courts when addressing the extraterritorial reach of California statutes. Okay. The Ninth Circuit explained if a state law does not have limitations on its geographical scope, the courts will apply it to a contract governed by that state's law, even if parts of the contract are performed outside of the state. The entire contract was performed outside of the state. The contract was for her acting services. She did not act at all, from what I remember, in California. Or if she did, it was in the second half, which she herself said it was fine, there was no problems. But my understanding is that all of the acting was done all of the film was shot in New Jersey and New York. So no part of it of her contract was performed in California. The Wayfarer parties do not identify any geographic limitations in the language of Section 47.1 or Section 3294. Thus, the parties' agreement to apply California law controls. Okay. Even if the presumption against extraterritoriality did apply here, it does not. The court should still apply Section 47.1 because the conduct relevant to Ms. Lively's motion has a sufficient nexus to California. The Wayfarer parties principally argue that there is no such connection because the film was shot outside California and Ms. Lively is not a California resident. This misses the mark. The relevant conduct here is the Wayfarer party's retaliatory litigation based on statements contained within Ms. Lively's complaint to a California agency, not the sexual harassment and smear campaign allegations underlying Ms. Lively's affirmative claims. And to the extent the Wayfarer parties concede that the filing and dismissal of their claims is relevant, those claims are clearly tied to California. It is undisputed that Wayfarer Studios is a California-based company which retained California-based attorneys to file a defamation action under California law, based in principal part on allegations made in Ms. Lively's CRD complaint. What? I don't understand the relevance of retaining California-based attorneys, though. Does Wayfarer also have New York-based attorneys? And as does she. She has attorneys from both New York and California, and Texas, actually, for Jed Wallace. I wonder if Jed Wallace could use this argument. Well, she's hired attorneys from Texas, so therefore Texas law applies. The relevant conduct, therefore, did not take place at wholly outside California. Sexual harassment did, and sexual harassment has got to be established for 47.1 to even apply. Therefore, Section 47.1 and Section 3294 would apply. Finally, strong public policy considerations weigh in favor of applying Section 47.1. The California legislature enacted Section 47.1 to protect victims of a sexual assault, harassment, and discrimination, and to ensure that perpetrators cannot misuse litigation as a tool of intimidation and retaliation. Allowing the Wayfarer parties to invoke California law as the basis for their affirmative claims against Ms. Lively in New York, a typo there, whilst simultaneously disclaiming its protections for Ms. Lively, would subvert that legislative purpose and strip Section 47.1 of its intended force. As the Second Circuit has cautioned, courts should not permit litigants to have it both ways, invoking the benefits of a legal regime while avoiding its limitations. Moreover, the presumption against extraterritoriality has never been applied to an injured person's right to recover damages from an unlawful act committed in California. Factual findings as to Ms. Lively's affirmative claims have no bearing on whether Section 47.1 applies. Wayfarer parties further assert that the court cannot rule on Ms. Lively's motion until a trier of fact determines that Ms. Lively acted without malice in communicating about the Wayfarer parties' sexual harassment and retaliation, and that Ms. Lively had a reasonable basis to report her concerns about the workplace. Ms. Lively is unquestionably the prevailing defendant in the failed defamation action. Yeah, but that's not the point. It's not the point. You can't just say, I've been sexually harassed, and then Section 47.1 applies. There is a stipulation baked into the statute that the complaint or the cause for complaint must have held reasonable basis and must be free of malice. It's part of the statute. You can't sit there and go, well, that doesn't matter. Their claims for defamation against me, which I've self-determined that they were retaliation. That makes me, it was all dismissed. I'm the prevailing party, so therefore I'm entitled to all of this. That's just rubbish. The court's dismissal order, which holds that Reynolds, Sloan, and the New York Times did not act with malice, including because Miss Lively gave them no reason to doubt her version of events, only bolsters this conclusion. Okay, let's go back and have a look at that. Okay. What did Judge Lyman actually say about that? The Wayfarer parties have not adequately alleged that Sloan or Reynolds individually did any more than repeat Lively's version of events, which they had no reason to doubt. And that makes sense. And the reason the judge would have said that is because Lively was the person who experienced the alleged acts, the alleged sexual harassment. So if she goes to other people and says this happened, there is no reason for Leslie Sloan or Ryan Reynolds to doubt her. That is what that means. And that is why Judge Lyman did not. That's why Judge Lyman limited a lack of actual malice to only Reynolds, Sloan, and the New York Times, but not Lively. Specifically, he made a point of saying that there was no finding of actual malice for everyone except Lively. And the reason for that difference is because everyone else was more removed from the acts. Lively was the one saying that she experienced them. She experienced them firsthand and she would have knowledge of them. Anyone else may not necessarily. So that is why there is a different standard, if you like, for malice. Not a different standard, that's not the right word, but the judge could not definitively say that Lively hadn't acted with malice. She's in a different position. It's really frustrating that she keeps twisting words. To insist Miss Lively reprove these, she hasn't proved shit. To insist Miss Lively reprove these facts at trial would cut section 47.1 off at the knees. She is going to be doing that anyway because she has brought her claims and she swears that she is not going to withdraw them. I don't think Wayfarer would allow her to withdraw them. So she is going to be doing this anyway. She's not being burdened any further because she has to prove her claims, prove the facts at trial. The California legislature made clear that section 47.1 remedies must be made available at the earliest stage to prevent protracted litigation that would re-victimize complainants. I think the purpose of making the remedies available at the earliest stage would be for people, I'm guessing, who, like if I alleged sexual harassment in the workplace, I told someone else, and the company lost business as a result, or it suffered some damages as a result of my statements, and then they attempted to to file a defamation claim against me and drag me through litigation, which I was not willing to do. I did not want to enter litigation. The difference here is Lively has voluntarily gone into litigation herself. She filed her lawsuit first against the Wayfarer parties. Wayfarer parties filed against the New York Times only first. And then that was the same day as Lively filing her lawsuit. So, in fact, I think Lively's was filed just before. So she has voluntarily put herself up for litigation, and everything that goes with it, with discovery, with having to go to trial and prove her claims. So the judge ruling on section 47.1 at the earliest point would be, it wouldn't save her from anything that she hasn't already volunteered to put herself through. So I don't see this argument makes no sense. I don't even know why they're making it, because she chose to bring a lawsuit. She chose to go through discovery, and she has chosen to put her claims before a jury. And getting the Judge Lyman ruling on the damages now, if he was to do it today, is not going to stop the fact that she still has her own claims, and they were there before Wayfarer brought any claims against her. And I love this next line because it's just shit. Forcing Miss Lively to endure a jury trial. Again, I refer you to everything I just said. She put herself voluntarily up for that. To establish what is already plain from this court's rulings would run contrary to the statute. This woman is exasperating. Nor do the Wayfarer party's attempts to muddy the waters by claiming Miss Lively's Section 47.1 motion presents the same factual issues as her affirmative claims withstand scrutiny. Whether Miss Lively acted without malice to make her complaints is not a necessary element of her affirmative claims. Miss Lively does not have to prove that she made a complaint at all to prevail in her sexual harassment claims. As for retaliation, Miss Lively must only prove that she engaged in a protected activity, i.e., that she opposed unlawful harassment. The Wayfarer party's contention that Miss Lively must first prove her entire retaliation claim imposes an unwarranted burden on Miss Lively, especially where the Wayfarer parties have already admitted that they believe Miss Lively made her complaints in good faith. Referencing a text message between Mr. Baldoni and Miss Nathan, in which both agree that Miss Lively genuinely believes that she is right and all of this is unjust. Do you know, there is nothing in that text message to say that that was referring to her belief that she had been sexually harassed. It could have been referring to the backlash that her ego was too big and too stubborn to accept that that wasn't caused by her own stupidity. But the transcripts we've seen of depositions have not pointed to any retaliation. In fact, she has, if I remember correctly, she's got nothing anyway, only what her lawyers told her. She has no evidence of any retaliation. She subpoenaed 107 random strangers, including me, who just sit and do this. We talk about her case, her public filings. We talk about it publicly and what we think and how much garbage it is. And she subpoenaed us and walked away with absolutely nothing from anyone. Why? She didn't even fight, right? The biggest fight she's put up so far has been with Perez and with Andy. And even with Perez, she walked away at the very first hurdle, like, oh, well, we need to do this and we need to do that. The judge was giving her something and was prepared to look at the communications and documents that Perez had. And she withdrew the subpoena. I think she would probably do the same for Andy. I think and I've said it several times, the only reason I think she is really sticking with Andy is because he has done a documentary and he has spoken to cast and crew who were actually there and saw what happened, what did not happen. And she is trying to get to that information in the same way that she has tried to get to, various third parties, such as the private investigators that Brian Friedman's firm hired, which is a completely standard thing for law firms to do. Source intelligence, is that? Then there was the law firm that they hired as well to investigate her claims, to investigate whether there had been a complaint of sexual harassment, and whether Wayfarer had acted correctly, remedied any issues. She didn't get to that either, but she attempted to get to the information that may damage her claims. And I think that maybe, she is trying to do the same with Andy, and that's why that subpoena has not been withdrawn. But, her subpoena against people like myself, like Cassidy, like Ken's, like Ashley, a bunch of us, without a crystal ball, but she got nothing at all. And whether people hired attorneys or whether, like us, we just did it ourselves and filed a motion to quash, the first sign of pushback, she withdrew and jumped ship. And I firmly believe because she knows there was nothing to get. She was just trying to intimidate people who were dissecting her case, making her look incredibly bad, had contributed something substantial. I've always said that those subpoenas were never in good faith. They weren't even issued. They weren't served correctly. They weren't executed correctly. And those mistakes shouldn't have been made. So I think they were just to be intimidating. And it worked to some regard. It had some success. It also generated a load of backlash from pro-Lively people because of the mischaracterization and the lies, like she's doing in this filing here. We had a bunch of pro-Livelies come and give us abuse because she implied that we met and conferred and that she got the information she was looking for, when in reality she met and conferred with the people who had lawyers acting for them. She didn't meet with any of the 5 of us who did our own motions to quash. And she didn't get any information, to my knowledge, not even from the people who had lawyers. So, but it made us look like we handed over something, like we were part of the retaliation campaign. And we got a lot of abuse and backlash, and still do to this day. Yeah, so I mean, that text message saying that she, may genuinely believe that she's right. That, I think that's more about the backlash, that it wasn't her fault, and I think that's purely an ego thing. In fact, I'm convinced it is, because and that all of this is unjust. It sounds like backlash, not sexual harassment. And the proximity, if I remember correctly, those text messages were a bit later on, like around the time of the premiere. It had to be, because Melissa Nathan was brought on board in July 2024. So those text messages weren't sent around the time of the actual alleged sexual harassment. So that's just ridiculous. And this court has already recognised the strength of the evidence in favour of the smear campaign. No, the court commented perhaps where it shouldn't on the evidence. The motions to dismiss should have been purely on the law, not the facts. And the judge, I think it's quite a lot of us agree that he overstepped a bit and went beyond what he should have and started to comment on some of the evidence. However, this was before her deposition, in which she went in and said that she has no evidence of a smear campaign. It was before we had all the signal messages, which turned out to be nothing more than, people trying to, almost sound tech illiterate people who are trying to fix problems and get a website up and running, a website that only held publicly available documents. Now we have that. Ms. Lively is entitled to actual, treble, and punitive damages. Finally, the Wayfarer party's contention that the court cannot award treble damages because Ms. Lively has not yet established her actual damages fails. Indeed, Ms. Lively seeks a schedule for the submission of damages evidence, which the court may then treble under Section 47.1. Further, contrary to the Wayfarer party's position, California courts hold that the judge or jury, as the case may be, has the authority to decide whether and what amount of punitive damages should be awarded. The court is therefore fully empowered to determine the application of punitive damages at this juncture. If the court concludes that further evidence is warranted, Ms. Lively seeks a brief evidentiary hearing on these discrete issues, which should be held separate from the trial on Ms. Lively's affirmative claims to avoid confusing the issues or the jury and to provide Ms. Lively with the prompt relief of the California legislature intended. Conclusion: for the foregoing reasons, the court should grant Ms. Lively's motion in its entirety. What? I don't think that she overcomes Wayfarer's arguments, in my opinion. But we will see. So take care, everyone, and I will be back with the next one.